Thank you, Mr. Clerk. And good morning and welcome to the Tennessee Court of Appeals. Your panel this morning consists of Judge Fryson to my right, and Judge Davis to my left, and myself, Judge McClarity. This morning, Mr. Clerk, do we have any preliminary matters before we start our docket?
No, Your Honor.
Okay. In that case, we're going to ask that you call the first case, please.
J. Mace et al. v. Nancy R. Helton et al.
For the ballot.
Good morning, Your Honors. Peter Ensign, Chattanooga Bar for the appellants J and Jane Mace. And Your Honor, there's really two issues on this appeal.
And I assume, have you already reserved the time? Have it already been reserved if you have time for rebuttal?
We'll reserve 2 minutes, Your
2
Honor.
minutes.
Yeah.
All right.
I think both parties have well briefed the issues. It's a straightforward case in one sense that this lease was created by the appellee, went for about 5 years with various fits and starts along the way, including the death of the original lessor, Mr. Bud Helton, which resulted in his son taking over, and that's when things got a little sideways. But the issues before this court are really just how Chancellor Atherton ruled on the case. That's why some of these evidentiary things that the appellee brought up as far as the filings, what we filed was the judge's ruling, which included the lease. That's the only things that are at issue. And neither party wanted to incur the thousands of dollars to bring the entire transcript up because it wasn't an issue of should he have allowed this evidence in or that evidence in. It was an issue of he was inconsistent in how he ruled, and that's why we brought that before the court. And why we believe it was inconsistent was the lease didn't separate the purchase option from the lease itself. The lease said if you default under the terms, the lessor has the right to terminate the lease, which Mr. Helton attempted to do, and the chancellor said he didn't do so effectively. That's one of the things in his ruling. So you didn't really even send him a notice, give him a right to cure or anything, and therefore, chancellor said he can go ahead and perform on the lease, which he did. So then to turn around and say, well, but you are owed attorney fees because you had to bring this action, that wasn't even consistent because he really didn't, he incorrectly brought an eviction action because he never sent the appropriate notices, but the Chancery Court action, the Maces filed because they realized, both parties filed at approximately the same time because they realized this thing was going sideways. So really, I think it's just as much a default by Helton as it was by Mace, because Helton prematurely breached the lease because the lease didn't say when the taxes had to be paid. It just said he was responsible for the taxes. And he had gotten behind on the taxes. When they brought it to his attention, he caught the taxes up. He tried to pay it off. Eventually, when he did pay it off, it included all the back taxes. The lease term allowed for that. It didn't say you have to pay the taxes on time. It just said you're responsible for the taxes. He paid all the taxes. He paid the penalties that were associated with any taxes that were late. That wasn't a default under the terms of the lease. All the other things that were cited in the one default notice that he received weren't even terms of the lease, and all of them were proved to not even be correct, which is why the chancellor said, no, you didn't even give him a chance on this, and then turned around and said, you can go ahead and perform, which he performed the very next day. So it's inconsistent to say, well, you can still perform under the lease. They didn't really even, they being Helton's, didn't even properly default you on the lease, but then turn around and say, however, Helton, you're entitled to attorney fees because he defaulted on the lease. Well, those two things don't match. And that's why we appealed that issue, and which was, even though we did an agreed judgment, it was only because the chancellor had read it all out and we needed to get something filed to get the monies released from clerk and master, because Mace had been paying all the money in during the pendency of the case. And we put in there, we don't waive our right to appeal these things because we knew that that was an issue. We shouldn't have to pay attorney fees when we weren't found to be in default. And secondarily, we filed that Helton, secondarily Adam, the son, had interfered with Mace's ability to sell the property by refusing to tell him what he owed, by refusing to cooperate with a potential buyer. And the chancellor didn't even rule on that issue. He talked about it in his ruling, but he never says anything about it. It implies that he denied that claim. But again, it's not clear or consistent. And we're saying, hey, Chancellor, you need to rule on that. We'd like that part sent back for him to rule on it. If he felt like the evidence wasn't clear, then have us bring some more evidence. If he felt like the evidence was clear, then explain what was the basis for denying that claim. Though, when you read his order, he doesn't really deny the claim. He just said, well, this contract, I don't think it's a good contract. It'd be very hard to complete that contract with an old building. And then he moves on to talk about other things. So those are inconsistencies in his final ruling. And those are the type of inconsistencies that are unfair, in this case, to Mace, but are unfair to litigants in general, is that they need consistent rulings so they can understand what exactly their rights were to even make things more clear on an appeal. Because to say, well, I'm going to give you attorney fees because you had to bring this action, you didn't bring the action. And you had just, Chancellor said, that Helton did improperly notice Mace about these alleged defaults, and you also appeared to rule that none of these defaults were even defaults, at least all the specific things other than the taxes. And I think the terms of the lease are pretty clear. It doesn't say anything about when the taxes were due. And the rent was not in default. He had paid it into the Chancery Court. There was some testimony it had been defaulted a year or two before, but he had caught all that up without any letters or any claim of default. So the lease was still in play. The Chancellor's ruling shows the lease is still in play because he allowed Mace to consummate the lease, which Mace did, paid in full the purchase price, and Helton's deeded the property to him. So those issues are clear. But then to turn around and grant attorney fees, no, not if my man's not in default. You can't make him pay attorney fees.
Is
And then
an attorney fee issue the only issue, Ms. Simpson, that your party is contesting?
Well, really, we also don't think the Chancellor ever even spoke to the interference with his contract. He just vaguely references that he doesn't think this is a good contract, but he doesn't give any specificity of, well, here's the contingencies that Mace didn't meet, therefore Helton's not liable for interfering with his contract, or on the converse, here's the solidness of this contract, and therefore Helton is responsible for breaking it because he wouldn't provide the payoff and he wouldn't agree to cooperate with signing a deed. He doesn't speak to either of those. In the Chancellor's defense, it was a very long trial, and he had the next day to close on the actual purchase, and he just went through it. But it's okay, but you skipped an important claim that we had brought up, and you didn't give us any clarity as to really, I mean, it's implied that he denied it because there's no judgment against Helton, but you can read it. You're not going to find where he denied it because he doesn't really rule one way or the other. So those are the two issues that we were bringing before the court. And my thought was all you really needed was the judgment. That's what I included with the transcript, because it's like, that's what we're arguing. We're not saying he made any evidentiary mistakes in what was allowed or what was denied. We're just saying, okay, you did a great job, Chancellor. You listened to all these witnesses, you accepted all this evidence, and you reviewed it, but your ruling is internally inconsistent. And so that's the issue that's before this court, and we're just asking, really, we think it should be set back for Chancellor to clarify how he came up with this. You know, if you believe that there was defaults, how can you allow him to close? If you can allow him to close and there's no defaults, how can you charge him attorney fees? And then if you don't think Helton interfered with this contract, give us the reasons. Then there might be some evidentiary issues that we would bring back on appeal to say, well, wait a minute, Chancellor, you said this, but the evidence didn't say that. But he didn't say anything except just a vague allegation that he didn't think that contract would be enforceable. Or he didn't even say that. He just didn't think it was a good idea. So those are the two issues that we're bringing before this court.
Thank you, sir. You have your rebuttal time. Yes, sir.
Good morning, judges. My name is Caleb Smith. I'm here for the appellees. In the appellee's brief, we raise a couple of issues of waiver. I'm not going to get into that today, just to let the brief speak for itself for that, but focus on the actual argument of the issues. So I'm going to start with the claim that the Chancellor did not rule on the Mace's claim for tortious interference with business dealings.
Mr. Smith, will you pull that microphone a little? Yeah, there you go.
Yes, Your Honor. Is that better?
Yeah.
Okay, thank you. The first issue I'm going to address is the tortious interference with business dealings. That claim was not raised by the Maces in their complaint. The claim raised was tortious interference with contract. In the brief, I cite to a case, I believe it's Med, where they are two separate causes of action. Tortious interference with contract and tortious interference with business dealings are two separate causes of action with separate elements. And so the claim made was tortious interference with contract, not tortious interference with business dealings. You know, Mr. Ensign, I believe, is accurate. The court doesn't explicitly say this claim is denied. It doesn't. The Chancellor discusses it, and he doesn't say denied, but he does say, you know, he's not awarding damages for it. And so the judgment and the amended judgment that both attorneys signed reflect what I believe is the attorney's understanding of the order, which is the Chancellor awarded judgment for specific performance as to the option and found default as to the lease, as to non-payment of rent and non-payment of property taxes. The Chancellor chose not to terminate the lease from my understanding of the judge's oral ruling. It is unclear whether the Chancellor terminated the lease or not. I think it's somewhat irrelevant for this appeal because the end of the lease term by its natural termination would have been the day after trial. And so whether the lease was terminated when the Helton sent a notice of termination or not, it became immaterial because the Chancellor allowed the Maces the option to purchase, to still exercise that option. So as for the claim that the Chancellor should have addressed a claim of tortious interference with business dealings, that is incorrect because it was not raised by the pleadings and there's no allegation that it was tried by implied consent.
Let me ask you this. How do you square the finding of a default with also the finding that they can, even though there's a default, they can still move forward and exercise the option?
Because under case law that I cited in the brief, Womble v. Walker, Adam v. Swift, an option to purchase and a lease agreement are separate contracts that can be in independent instruments or that can be combined into one instrument. And then it was, I believe, Womble, where it's if the two rights, the option and the lease, are supported by one consideration, then they are separate but not severable. I was unable to locate a specific case dealing with a situation where an option and a lease agreement are in the same instrument but supported by different consideration, which I believe
Is that your client's position in this case, that there was separate consideration for each contract or each portion of the contract?
Yes, Your Honor.
So what was the separate consideration
So
for
the
the
separate-
lease and the option?
Yes, Your Honor. For the lease, it was monthly rent payments of $3,000. And then also under the lease, there was a $5,000 deposit for the option to purchase. And that is in, I believe, paragraph 2 of the lease agreement, which is in the supplemental technical record. Yes, Your Honor. Purchase price and option is the heading. And so that is how we square this situation is, yes, you can find a default on the lease and award damages for default on the lease, but still say the option is in effect and grant the individual with the right who owns the option to purchase the right to enforce that. Adam v. Swift and Gulf, there's another case, but Gulf Refining, I believe, it stands for the proposition that with an option to purchase, it is the court should extend the time to exercise that option to the fullest extent available by interpretation. In this situation, the chancellor said, it's the full lease term as anticipated by the lease. So ending May 1st, 2024, which is what the chancellor did in this situation.
Did the trial court make specific findings with regard to consideration?
He did not, Your Honor. There was no specific findings as to whether the option and lease were supported by separate consideration. Additionally, there was some discussion about whether the Heltons properly terminated the lease agreement. There was a notice of termination. It's attached to the Heltons' answer and counterclaim in this case. The procedural history is the Heltons sent notice of termination and filed a general sessions eviction lawsuit. From there, the Maces filed a chancery court action requesting specific performance, breach of contract, I believe, and tortious interference with contract as to Adam Helton. From there, the General Sessions Court transferred the case to Chancery Court. We were concerned that that was not spelled out. It's not clear that the General Sessions judge has that ability to transfer directly over to Chancery Court, so we appealed it to Circuit Court, and then from there asked the Circuit Court judge to consolidate the case in Chancery Court just to make sure that all the procedural steps were met correctly. And that is where this case was ultimately tried. So yes, the Heltons did bring this action for eviction. The chancellor did not find that the lease was terminated. However, he did find that the Maces were in default for non-payment of rent and not paying property taxes. And then that is our argument on appeal, and the Heltons would ask for their attorney's fees on appeal, as this is part of the same lease agreement that they're defending for the default judgment. Are there any additional questions I could address?
Well, I want to ask that, and I'll ask Mr. Insling the same thing. What is the final results here? What have, as far as the parties, what do they finally stand at this point? Have the property been transferred?
Yes, Your Honor. The property has been transferred to Mr. Mace and Miss Mace. Payment was made on May 1st. The parties executed the option to purchase. By the terms of the option, the way to exercise the option was to make payment. The notice was inadequate. notice of intent to exercise the option was inadequate. It was the actual tender of payment. All right. Thank you, Your Honor.
Sure thing.
Your Honors, this issue of whether an option and a lease can ride separately, notice the clarity with which Chancellor Atherton on page 5 of his ruling addressed this issue. He said, but in terms of the drafting, the testimony that I received with this document was drafted by Bud Helton. So therefore, for the purposes of interpretation, the contract is construed against the drafter. See, that's clear. That's not confusing. That's not inconsistent. But that also means you can't now fall back and say, oh, we meant for this to be two separate contracts. You drafted the contract. There's nothing in here that says it's two separate contracts. So to come now and to argue, well, wait a minute, it's two separate contracts. You drafted it. It doesn't say that. It's one contract. It says right on the top, lease with option to buy. So Chancellor clearly said you have to interpret this against Helton. And there's no way he can try to imply that it was two contracts. It's one contract. And the issue of how did things end up, that's the whole issue. The Chancellor said, well, you can go ahead and perform under the contract, even though you defaulted under the contract. Wait a minute. If you defaulted, the contract is terminated. Helton tried to terminate it. That's the whole reason for this appeal. He sent a termination. And if you read through the Chancellor's order, it is a little confusing, but he's basically saying, and he says it clear, there's an implication of reasonableness in your notice of intent to terminate. And then he kind of goes through all the things that Helton put in his letter. And then he says, I'm going to go ahead and let him perform on the contract. Okay, great. We think we won. Then the next thing he says, but I'm going to go give you $25,000 in attorney fees because you had to bring this action. Those two things don't match up. If your notice of intent, your notice of default and intent to terminate is determined to be invalid because the evidence shows that these issues of default hadn't actually occurred, then don't charge me attorney fees, but then allow me to perform the contract. Either say, yeah, you defaulted and you can't go any further, or you didn't default and you can perform. You can't say both, and that's what happened. And you can't come later and say, well, I meant for this to be two separate considerations. That's not clearly spelled out in this lease, and you drafted the lease yourself. And so there's no clarity whatsoever in that. That's really what we're saying is you can't do that. And either just strike that, order him to disgorge the attorney fees, which have already been paid, or send it back to Chancellor for some clarity as to how he could come up with that. And the same with the tortious interference. They are separate claims, but in this case, they really were just melded together because there was one specific contract, but then there was the lease itself, which was his business that Mr. Adam Helton was completely interfering with throughout the course after he took over, with all these allegations about homeless people and different things that really had nothing to do with the lease, nor were spelled out in the lease. So we think that issue was properly brought up. The Chancellor very vaguely recognizes it in his ruling, but there's nothing specific, there's nothing clear, there's nothing that I can bring to you three judges and say, well, look, he ruled this, but the evidence said that. I'm not sure what he ruled, except you can perform and you owe him $25,000. That's fine, but that's not really consistent, and it makes for a very difficult ruling. So that's...
Your time is up, but I want to ask you the same question. The property has been transferred.
Yeah.
The payment has been made.
Correct.
Okay.
During the pendency of the court case, the money was deposited with the clerk and master. So once the ruling came down, it was on the 30th, the 30th was trial. So the ruling was kind of late, and then we closed the next day, transferred money to Mr. Caleb's escrow and had signatures. So everybody was prepared, waiting to see what the ruling would be.
Okay. Thank you very much. Thank you both for your presentation. Your case has now been submitted to this court for resolution. You should receive our opinion and judgment within a reasonable